Hardly a week goes by without someone coming into our office and inquiring of us, asking us about how they might clean their criminal record or get something removed from their criminal record. In Texas, there are two specific remedies that a person may be entitled to that can help with that scenario. The first of which, and the best option, is an expunction. For certain folks, if your case was dismissed, if you were found not guilty, or if the case was no billed by a grand jury, you may be eligible for an expunction. Now, an expunction is a complete remedy. It actually is an order from the court that directs all agencies who have any record of your arrest or case to destroy those records, and it actually provides civil and criminal penalties for anyone who, after an order of expunction, then divulges that information. So it's a strong remedy and it's a complete remedy, and it even allows the person the ability to deny the fact of the arrest or the existence of the case. So that would be the best option. Not everyone is eligible for that, and it is limited to instances, certain instances of dismissal, not guilty verdicts, and cases that have been no billed by a grand jury. That leaves the majority of people that come to me asking that question in a little bit of a lurch, because maybe they several years ago pled guilty to a case that they received deferred adjudication for, and they believed at the time that they received that deferred adjudication that meant it was not going to go on their record. Now they have realized that that's not true. They have had a background check performed by a prospective employer or school or a licensing agency, and that old deferred adjudication probation that they received is coming up. That person is not eligible for the expunction that we discussed before. However, Texas law does provide a significant remedy for those people who have successfully completed deferred adjudications in most cases. That remedy is called a petition for non-disclosure. The good thing about a petition for non-disclosure is that it essentially is the adult equivalent of juvenile records being sealed. It is having your adult criminal records sealed from public view. That information would still be available to law enforcement and certain licensing agencies, and again, not everyone is eligible for a petition for non-disclosure simply because you successfully completed deferred adjudication. Both with expunctions and with petitions for non-disclosure, it is important that you seek legal counsel who understands those laws and those remedies and can give you advice about how those things might apply to your case. If you have a prior deferred adjudication or a prior criminal case that was dismissed, no billed, or found not guilty, please give us a call here at Parnham and McWilliams and let us ascertain for you whether or not you may benefit from a petition for non-disclosure or from an expunction.